Commissioner, it's very good to see you again. I, too, believe that the government should proactively consult with you in not only the development of these applications, but certainly as they are leading the way in partnership with provinces in the development of these applications. I think it's really important. I want to ask about the principles that you espouse. When I go down the list, I agree with almost every single one. And so when I look to purpose limitation, of course, that makes sense. When I look to the collection of data being necessary and proportionate to the matter at hand, that of course should be a key restriction. A clear legal basis I agree with, and I want to get back to that. Time limitation, agree. Transparency, accountability, oversight. I think your office should be involved in that oversight. When we talk about a clear legal basis, you in your joint statement with other privacy commissioners, and then again here today, have indicated that it should be consent-based and entirely voluntary. I wonder what you think about opt-in versus opt-out, and would opt-out be sufficient in the circumstances where, if we didn't have an opt-out system and we were only looking at opt-in, we couldn't get the adoption rate necessary for the system to work at all?
So to be clear, you're correctly putting in your question the question of legal basis and consent and voluntariness. Under federal private sector law, et encore une fois, je vais changer en français peut-être.
Once again, I'll change into French. Maybe it isn't necessary at this point, but it seems to me that it's better for interpretation if I speak French. Consent is necessary, but if the application is used by the provincial governments, for example, by the provincial health authorities, it is possible that that consent would not be legally required. The essential point that the commissioner, myself, and my provincial colleagues have to deal with is this: consent has to be voluntary, and therefore you have to promote the people's trust in the use. People have to trust in an application. There should be consent, therefore.
I agree that there needs to be trust, and I think it should be privacy preserving in every possible way. And I agree with the principles you put forward. And I would say also, as it relates to protocols, whether it is the DP3T or whether it is the D3PT or whether it is the TCN protocol, I do think there are other ways we can preserve privacy. I do wonder, though, in your statement, you say de-identified or aggregate data should be used whenever possible, unless it will not achieve the defined purpose. And if I take that same approach to say we're going to abide by these ideas unless we have to say, on balance, in the best interest of the public interest overall, the app won't achieve the defined purpose if we have an opt-in system only, and if instead an opt-out system would get the adoption rates we need, would you be opposed to that?
I'm not sure how that works in practice.
I asked Google, as an example, I asked Google at our committee the other day if the app could be put on individuals' phones by way of an OS update, and people would have a choice as to whether to do that or not, but it would be effectively automatic, and then people could choose to opt out. That could be one way of doing it.
Potentiellement,
potentially, yes, but people should have the choice of traveling and moving around in society without having to hang on to a telephone. In practice, if not in law, consent is the voluntary characteristic here in terms of the use of the app and consent.
Because I only have a few minutes left, can you give our committee an update on your efforts to take Facebook to court?
Yes, I'll have to be careful, obviously, because we are before the federal court on this issue. Après le rapport d'enquête qu'on a.
After the inquiry in the spring of 2019, and at the beginning of 2020, we referred the issue to the federal court and asked the court if it could order Facebook to comply with our recommendations. because, as you know, Facebook, to constrain Facebook to accept our recommendations. So, as I said, we addressed the federal court in 2020. Facebook brought in an application to quash our request to the federal court. The federal court, it was seeking to have the federal court not ask Facebook to comply with federal regulations. So it is still before the courts.
I previously indicated that I thought Facebook was breaking the law. They denied it, and turns out that they did, in your view, certainly. And I think it will be the view of the federal court. I take the same view of Clearview AI, and I encourage you to bring the full efforts of your office brought to bear against Clearview AI, who have clearly broken the law of Canada in relation to our privacy laws. Thanks very much.